or it was a crime of a petty or more minor nature, then the Home Office and the Secretary of State has the discretion to overlook that crime, assuming it is not a repeated offender. So maybe that person has just once during their residency in the UK come to the attention of the immigration or human rights authorities. Immigration authorities or police authorities, I beg your pardon. So it's still possible to make an application and not be penalised or prejudiced for any criminal background. So effectively, where there's such a situation, one should get expert immigration advice again and look at the merits of making such an application. Now, in the meantime, I've been told that we need to go to commercial break, so I would like to thank you for watching the first part of the Legal Hour with myself, Raheela Hussain, Principal Solicitor of Greenfield Solicitors, and I hope that I will see you right after this commercial break.
This is the Pauline Long Show. It's a very popular global talk show. As you know, watching us from right here in the UK, you can always tune in on Sky channel 182. That's Ben Television. We want to discuss issues that affect you. Hi, this is the Pauline Long Show. It's a very popular global talk show. As you know, watching us from right here in the UK, you can always tune in on Sky channel 182. That's Ben Television. We want to discuss issues that affect you. Hi, this is the Pauline Long Show. It's a very popular global talk show. As you know, watching us from right here in the UK, you can always tune in on Sky channel 182. That's Ben Television. We want to discuss issues that affect you.
Hey, this is Katie. Keep watching Ben TV on Sky 182.
Good evening and welcome back to the Legal Hour on Ben TV with myself, Raheela Hussain of Greenfield Solicitors. Greenfield Solicitors are a firm of specialist immigration and human rights solicitors based in North London. We provide an entire service in all aspects of UK immigration law applications for persons seeking leave to remain, leave to enter, or an extension of stay in the UK, and we are very much used to dealing with simple applications up to very complex applications, including deportations of British nationals. So if you do have any immigration and human rights questions and require advice from me, then please do call us on 0208 884 1166 at Greenfield Solicitors in order to book an appointment with myself. Our offices are open Monday to Friday, 9:30 to 5:30. In the meantime, I would invite our Ben TV viewers to give me a call on the current live show that I'm presenting. Please do ask me your questions on 0208 808 0693 and I'd be happy to attend to any questions. In the meantime, I've been told that we have a call online. So good evening, caller. Good evening, madam. Please just speak up for me.
Okay, can you hear me now?
I can, yes. Please go ahead.
Okay. Yeah, I was married to British national.
Sure.
Yeah, and they gave me 2.5.
Okay.
So which I will have to renew 4 times.
Yes. Is it discretionary leave to remain visa then?
Yeah.
Okay.
Yeah, but when I called them twice, they said I have to go back to my country so that they will give me another 2.5 to renew twice.
You have to go back to your country. I wouldn't say that's necessarily the way it should be. If you've been granted discretionary leave to remain in the UK, based on making an application here, then as you have identified, it's the 10-year route if that's what the Home Office actually said. So every 2.5 years, you have to make the application before your current visa expires. Usually that's within 28 days. So you have 28 days before your current visa expires to ensure that this application is made to the Home Office. And we have a picture of the Secretary of State right there on our screen at the moment. That's Theresa May. And she is responsible for actually addressing all immigration applications made to the Home Office. Now, if she's satisfied that your circumstances warrant a further grant of discretionary leave to remain, you will be granted a further 2.5 years. Obviously, please do ensure that your application that you submit is the right one. There are lots of different immigration applications, so you need to make sure that when you submit the application, it is the correct application form that you've completed, the correct version, so make sure it's not outdated. Make sure you've paid the correct Home Office fee, the IHS fee, make sure it's submitted with all the documents required, original documents, and ensure, if I was you, to get legal representation to ensure it's done properly. Now, you can't, after 2.5 years, usually go out of country, and I'm not sure what you're referring to, that you can get another 2.5 years out of country. I've not come across that. Usually our clients, anyway, at Greenfields, always make these applications in country. The only circumstances where you would seek to go out of the country, for example, is where you're thinking, gosh, I don't wish to wait 10 years to get indefinite. Let me go out of country. Let me apply for a spouse visa to re-enter the UK. So you apply for a different visa. And you can only do so if your partner is of the circumstances where he earns more than £18,600 a year.
Yeah, that's what I want to do. I want to change it.
So if you wish to, sure, you can go out of country, apply for that visa, but do bear in mind a spouse visa is granted for 2.5 years, then you have to apply for a further extension of another 2.5 years. So after 5 years of holding a spouse visa, you are eligible to apply for indefinite leave to remain under the current rules. Bearing in mind you've already done 2.5 years, the question is, if you're willing to go out of country and apply for a spouse visa and then apply for another 2.5 years after, then you've saved yourself 2.5 years, because then you would be eligible to apply for indefinite after 7.5 years and not 10, if that makes sense. So you can shorten the time that is required in those circumstances, but it does require you to go out of country. Okay, thank you for your call. So Theresa May was a picture you just saw on your screen a few moments ago, and she is the Minister responsible for immigration and also for deciding whether somebody should be granted British nationality. Now, many of our migrant clients, obviously their aim is to one day naturalise and be granted a British passport to remain in the UK, and they want to be British citizens, because as we know, indeed, it is a very huge privilege to be granted a British passport and be a member of British society. Now, what we have noticed in recent months, perhaps in the last 12 months in my practice at Greenfield Solicitors, is that we have seen people who have made applications by themselves for naturalisation of British nationality, which are relatively quite straightforward. If any of our viewers have actually noted or done the application, they would note that the application for British nationality is quite simple. It's just an application form. It requires information, photographs, the fee and so forth, and then usually we find that the Home Office provide a decision within 4 to 6 months. However, we have come across people calling our offices or attending for appointments, and they say, I made this application for British nationality, but I have been declined it. Even though I satisfy all the criteria, the Secretary of State has actually stated in the letter which refuses me British nationality that because of my past immigration history, I was here unlawfully and I worked illegally, obviously, and not declaring income. They have decided that I am not of good character and I am not entitled to apply for British nationality for X number of years until, for example, 2018 or 2020. You know, what can I do? Or we've had people, all sorts of different situations, in fact, the Secretary of State has raised that they do not meet the good character requirement, which is a fundamental criteria that an applicant must meet in order to be granted British nationality. Now, I should point out, unfortunately, with applications for British nationality where they are declined, there is no right of appeal. So a migrant cannot say, right, I wish to appeal this application, I want a judge to look at it. No. With British nationality applications, there is no such right. All one can do is usually either decide to reapply or they can ask for, you know, the Secretary of State to reconsider. But we find in practice it's not always possible to get a successful decision reconsideration. So where one has been declined, get legal advice, speak to a solicitor, see if it's possible to get round or try and make an explanation or case on the good character requirement to apply earlier, or you would need to maybe wait for the period of time specified in that letter and apply even if it is after a few more years. We have another call. Please go ahead. Good evening, caller.
Good evening.
Good evening, sir. Please do go ahead.
Yes, I'm working. I want to bring spouse and my children.
Right.
I'm working £17,000 in a year.
Yeah.
My other job, I'm earning £800 in a week, second job.
Right.
I want to know how long you have to be in that second job for before you submit your application.
Of course. How old are your children, sir?
15, 16 and 10.
And where are they based?
They're in Africa.
Africa. Okay, which country?
Nigeria.
Oh, sure. And may I ask where their mother is, please?
They are both there, all of them are here.
Okay. Are you bringing the mother as well, or just the children?
All of them, 3 of them.
Oh, see. Okay, I understand. So you wish to sponsor them on a spouse visa?
Yes.
Okay, sure. Now, the current criteria, according to the information I have to hand, is 27,200. So that's where an applicant is coming to the UK and they've got 2 dependent children. So that takes into consideration the 18,600 requirement for your wife.
Yeah.
And then the financial requirement is topped up for each child. So the figure at the current level is 27,200 based on the information I have to hand. Okay, so that would be the financial requirement. Obviously, sir, you do need to hold any employment position for at least 6 months because you do need to provide the pay slips, the bank statements and things like that when you make a spouse visa application. And it would be, I guess, what you would be doing is applying for the children at the same time, so they're dependents of their mother, and you would be seeking to obtain leave to enter for all of them at the same time. And as I highlighted earlier, if the application is successful, so if it's Nigeria, it's Lagos or Abuja, the British High Commission's there, they're currently taking about 3 months to issue decisions on settlement visa applications.
Yeah.
So that's a time frame you can look at. And do ensure, along with the financial documents, which I'm actually going to go into just after I answer your question, that the other requirements are satisfied, including the relevant English language test, which your wife will need to undertake.
Yeah.
Also, there's TB tests that migrants will need to undertake. And I cannot emphasize the need of making sure that the information you provide on the online visa application form is accurate, is correct, there are no errors, and you are totally honest on all questions, because in no way do we want the entry clearance officer at the British Embassy to be unclear on the information provided. Okay, thank you for your call. So, very helpful, the call we just had. He actually asked what kind of, what's a procedure to bring my wife and children over. Now, it's not just the procedure. I would actually like to highlight, give an overall summary of the kind of documents that would be required. So, for example, where one is employed, so the British person is employed in the UK, what kind of documents do they need to bring to the UK? Do they need to provide with that visa application in Nigeria or Ghana when they support their wife or their children to come over? Now, the kind of information required if the British sponsor earns a financial requirement and they are in salaried employment, so they are an employee, include the last 6 to 12 months pay slips, the last 6 to 12 months bank statements, thereby showing that the salary from the pay slips is paid into that particular bank account, which should obviously be in that person's personal name, along with a letter from their employer which can confirm their position, the start date, their role, whether they're full-time, part-time, how long they've been on that particular salary for, and also a copy of their employment contract. The other type of information, if possible, is a P60. This is not an exhaustive list, but it gives you an overview of the kind of documents that one will need to submit when applying for a particular visa, and be it for a spouse or some other where the British Embassy is required. Now, where the person is self-employed in the UK, so the British sponsor is self-employed, the documents are obviously entirely different. We do find that they tend to be more cumbersome, more complicated, and a lot more. To give you an idea, the kind of documents where one is self-employed, they need to show their latest annual assessment tax return to HMRC and proof of registration with HMRC to show that they are indeed self-employed, and also where they hold a business bank account, the last 12 months business bank account statements. And if they have personal bank account statements, they should also provide that. They need to show that they obviously pay national insurance, and then they can either show their latest audited annual accounts from a proper registered accountant, certificate of VAT, and any franchise agreements if there is a franchise business. So again, if you want to get advice, please do contact a firm of solicitors to advise you further. Now, I believe we have another call, so I will go ahead and take that call. Good evening, caller. Good evening, caller.
Hello.
Hello, madam. Please do go ahead.
Yeah, my name is Florence. I'm calling from Manchester.
Hi, Florence.
Yeah, my mom has been coming to the UK for the past 4 or 5 years.
Sure.
And her visa just expired in February. And when she then applied again, they refused her visa, saying that she's coming here to work.
Did she visit all this time before in the UK? She just visited you?
Yeah, she's been visiting me for the past 4 or 5 years.
So you're saying she applied for a further visit visa to come and see you in the UK. Why did the British Embassy assume that she was actually working? What intelligence did they?
I don't know. She's been coming to see the kids and myself.
I beg your pardon?
She's been coming all these years to see me and the kids all the time.
So obviously there must be some information for the British Embassy to assume that your mother was working. Otherwise they can't obviously just suggest that. Do you feel there's anything that indicates that your mother was working here? Did she breach her?
No.
Okay. So...
She's 65, so she can't walk.
Yes, of course, that's right. It is a criteria, it's a requirement of a visit visa that one cannot work. So why do you feel, what did they say in the refusal notice, the entry clearance officer?
Yeah, what they said is what I've just said, that they feel that she's coming to work. They feel so that they are not convinced that she's not coming to work. That's what they said.
How old is your mother?
Yeah, my mom.
How old is she?
She's 66.
66, okay, thank you. All right. Does she work out there in your home country?
No, she's retired. She's a retired teacher.
Sure, retired teacher. Does she get a pension out there?
No, long time ago, no. She left and she went into business.
Of course. And how does she financially support? Do you send money or how does she live financially?
I do send her money. My elder brother as well in Belgium, I do send her money as well.
Okay, so she's getting foreign support, yeah? Okay, that's quite unusual. I mean, your mother is of senior years, so you wouldn't really think a lady of that age who's retired would be working in the UK if she visits you and your brother in the UK. So we're unsure at this stage of what intelligence the British High Commission have. Obviously, if they've made some sort of massive error and then they've got things totally wrong and accuse your mother of working in the UK when she was just simply visiting, then perhaps one suggestion would be for her to reapply for a visit visa. I would like to point out there is no full right of appeal, unfortunately, with visit visas. They abolished that a couple of years ago. So, unfortunately, unless there's limited grounds, such as Race Relations Acts or very specific human rights grounds to bring an appeal on, which in practice is extremely difficult, we often say to clients, look, just reapply, put a fresh application in. If you've got refusal, in your case, you know why they've said no to her. Put in evidence that shows, look, she doesn't work. Here's maybe money transfer slips from myself and my brother showing that for the last 6 months or 12 months we have been supporting her financially. She doesn't work. If she's of ill health, you can show medical evidence showing she's incapable of working. So you want to try and negate and argue against what the entry clearance officer has said, obviously in a respectful way. Okay? So I hope that's of some help to you. Thank you for your call. So going back to the issue of documents. So I highlighted the kind of documents that you would need as a self-employed person. Now there are people who are sole traders and partnerships or directors. So there's a whole medley of different criteria. So it's not easy. The Home Office doesn't make it easy. Indeed, the website I have found, even as a very experienced immigration and human rights solicitor, to be quite cumbersome. So I can only imagine how it is for people who don't have immigration background to try and maneuver the Home Office website, to try and find information and documents. And there are so many immigration forums out there. I would like to highlight a particular point. Sometimes I have clients who come to me for consultation and they say to me, Miss Hussain, my friend told me this, or my brother told me this, or the people at church told me this. Is this right? Is this wrong? And often I'm looking at the client and thinking, what on earth are you saying? This information that you've got is totally wrong. It's not immigration law. It's not human rights law. and it makes no sense. And often the client will say, well, I didn't want to come to lawyers because my friend told me there's no case, or they said, no, you shouldn't go to a lawyer, you can't trust a lawyer. They'll tell the Home Office that you've come there, they're not on your side. This is wrong. This is absolutely wrong. We, as immigration and human rights solicitors, are regulated by the Solicitors Regulation Authority. In order to become a solicitor, there are many, many years of study. I myself undertook a 3-year LLB law honours degree, after which I then had to undertake a legal practice course, in other words, a 1-year specialist course to undertake solicitors' exams, and thereafter 2 years training as a solicitor. And during our training and education, we are taught the highest importance of client confidentiality and to work only in the best interests of our clients, best interests of our clients, I beg your pardon. I'm so used to arguing best interests of children, sometimes I forget, but best interests of the client. So please do not be scared, do not be fearful. If you have a problem, everything is always in confidence, absolute confidence. And at Greenfield Solicitors, we often only ask your first name if you need advice. Okay, thank you. And we have another call, I believe. Good evening.
Hello, good evening.
Hello there, how can I help you?
Yeah, I'm calling to find out. I've got a daughter of 12 years old, and I want to know if I can apply for a permanent residence for her, but she wasn't born here.
How long has she been in the UK?
She's been here all her life. She came in as a baby at 6 months old.
Oh, wow. Have you made an application before?
She already has what I have, which is the 5 years EA family member residence.
I see. Okay, and when does that expire, please?
October this year.
Okay, the 5 years. Oh, well then she would be in a position to apply for permanent residence along with yourself.
I don't know.
Oh, okay. All right, just to summarise, obviously from the few facts that you've provided, I'm assuming she's a dependent of you, as you're the mother and she's the child. I'm assuming you're married to a European spouse?
Yes. Yeah.
And you've applied the 5-year residence card under the EEA regulations, and you both have been granted the same period of leave, you and your daughter. And I'm assuming when it expires just before, you're going to make an application to the Home Office requesting that you be granted permanent residence, which is unrestricted for you and your dependent daughter. Indeed, that is the procedure. I very much hope that you do fulfil the criteria, you have your documents in place and there are no issues. Just to let you know, it's a tiny, tiny fee the Home Office charge. You're very lucky, it's currently £65 in order to apply for permanent residence. That's per person, so it's quite nominal for you and your daughter. But yes, absolutely, that is the procedure one would do. Okay, thank you for your call. I would also like to go back to the point I was just making about confidentiality. So do not feel in any way that the information submitted by a solicitor to the Home Office is going to be used against you. Sometimes clients say to me, Mr. Hussain, I want to put in my application where I live, where I work, but I'm scared that if the Home Office come to my house or if the application is refused, what will happen? What will happen? Are they going to come and get me? Are Capita going to come and get me? To highlight Capita, as you can see, there's a picture on your screen, Immigration Enforcement. They work hand in hand with the Home Office. Capita is an organisation that was recently established with the aim of keeping statistics and putting pressure on migrants who do not have lawful status or leave to remain in the UK, to put pressure on them to leave the UK. So often you'll hear Capita sending letters to people whose visa may have expired or is due to expire, even by 1 day or 2 days. They're quite on it at the moment. Or they'll be texting or emailing people, and they get their personal contact details actually from the Home Office. So the Home Office appear to have a department which is very much on immigration enforcement at the moment. And Capita tries to get these details, put pressure on people to force them to leave, because as I highlighted earlier, the aim of the Conservative government at the moment is to try and limit net migration to the UK. It is indeed a very, very high priority, as our audience members will know, having read the news on a day-to-day basis and having listened to David Cameron, the Prime Minister, whose aim is to limit migration. Now, I should point out that, the UK is a tiny island, and we very much obviously have a wonderful culture, and we have people from all over the world adding and progressing, and therefore in some ways, though as immigration solicitors we are sympathetic to our clients and we very much do everything